Below is a clear, structured, examinatory explanation of all the headings you provided on the Prevention of Money Laundering Act, 2002 PMLA. You may use this as notes, assignment content, or for classroom explanation. The Prevention of Money Laundering Act, 2002 PMLA. A comprehensive outline with explanations a need for combating money laundering. 1. Threat to economy. Money laundering converts illegal money into clean assets, destabilizing financial systems, creating unaccounted wealth and encouraging parallel economies. 2. Threat to national security. Proceeds of crime often fund terrorism, drug trafficking, smuggling, organized crime. 3. Loss of revenue. Laundered money bypasses tax systems, causing major revenue loss. 4. International obligations. India is a member of the Financial Action Task Force, FATF, which mandates strong anti-money laundering laws. B. Magnitude of money laundering, its steps and various methods. 1. Steps in money laundering, 3-stage process. 1. Placement. Introduction of illegal money into the financial system, e.g., deposits, purchasing assets. 2. Layering. Creating complex transactions to hide the illegal source, multiple accounts, shell companies, crypto, offshore accounts. 3. Integration. Reintroducing the laundered money into the economy as legitimate income, real estate, business investments, luxury assets. 2. Common methods of money laundering. Hawala transactions. Shell, fake companies. Trade-based laundering, fake invoices, over-under invoicing. Smurfing, multiple small deposits. Real estate purchases. Cryptocurrency channels. Charities and NGOs used as fronts. See the Prevention of Money Laundering Act, 2002. Important definitions. 1. Attachment, Section 2, 1d, prohibition on transfer, conversion, disposition, or movement of property suspected to be involved in money laundering. 2. Money laundering, Section 2, 1b, plus Section 3, any process or activity connected with the proceeds of crime including concealment, possession, acquisition, use, projecting or claiming it as untainted property. 3. Proceeds of crime, Section 2, 1u, any property derived or obtained, directly or indirectly, from criminal activity relating to a scheduled offense. 4. Reporting entity, Section 2, 1-va, includes banking companies, financial institutions, intermediaries, and persons carrying on designated business or professions. 5. Scheduled offense, Section 2, 1-y, plus schedule, offenses listed in the Schedule to PMLA, includes OIPC offenses, cheating, forgery, criminal conspiracy. ONDPS, POCSO, Arms Act, Wildlife Act. O Corruption Act offenses. O FEMA violations, customs offenses etc. Offense of money laundering, Section 3. A person is guilty if they directly or indirectly attempt to indulge, knowingly assist, or are actually involved in concealment of proceeds of crime, possession, acquisition, use, projecting, claiming it as untainted property. After the 2019 amendment, continuing possession of proceeds of crime itself is an offense. Punishment for money laundering, Section 4. Rigorous imprisonment, 3 to 7 years. If offense relates to NDPS Act, up to 10 years. Fine, no upper limit, can be very high depending on the amount involved. Enforcement provisions. 1. Attachment of property, Section 5. Director, Deputy Director can attach property if he has reason to believe that the person is involved in money laundering and the property is likely to be concealed, transferred, or dealt with to frustrate proceedings. Temporary attachment is for 180 days, subject to confirmation by adjudicating authority. 2. Survey, search and seizure. Section 16 survey, conducted to verify the correctness of information, inspect records, or check activities of a reporting entity. Section 17 search and seizure. Authority can search premises and seize property, documents if there is reason to believe involvement in money laundering. Section 18 search of persons. The authorized officer can search any person suspected of possessing proceeds of crime or related evidence. 3. Power to arrest, Section 19. Director, authorized officer may arrest a person if there is material showing involvement in offense of money laundering. Grounds of arrest must be in writing and the person must be informed. Adjudication under the Act 1. Adjudicating Authority, Section 8. Confirms or quashes provisional attachment orders. After hearing, it may order or confirmation of attachment, or confiscation of property, or release of property. 2. Special Codes, Sections 43 to 47. Central government designates codes as PMLA special codes. They try or offences under Section 3 or scheduled offences if assigned by the government. Bail governed by stringent conditions under Section 45. 3. Vesting of property in the central government, Section 9. Once confiscation is ordered by the adjudicating authority and confirmed by the special court, the property vests absolutely in the central government, free of all encumbrances. Preventive mechanisms under PMLA *1. Obligations of banking companies, financial institutions and intermediaries, Sections 12 and 12A. These entities must 1. Maintain records of all transactions. 2. Provide information to the Financial Intelligence Unit, FIUIND. 3. Verify client identity, KYC norms. 4. Identify beneficial owners. 5. Maintain record for 5 years. 6. Report suspicious transactions. 7. File cash transaction reports, CTR, and suspicious transaction reports, STR. Section 12A. Director, FIU, may call for additional information. 2. Reciprocal arrangements with other countries. Overview of Chapter 9, Sections 55 to 61. Chapter 9 deals with international cooperation. 1. Letters of request from foreign countries. 2. Exchange of information between Indian authorities and foreign counterparts. 3. Attachment, seizure, freezing, and confiscation of property located outside India. 4. Assistance in investigation and trial of money laundering offences. 5. Arrangements for service of summons, execution of warrants. These provisions support India's commitment to global anti-money laundering standards. If you want, I can also prepare. Here is a clear, concise, exemplary note on the case Ram Jethmalani v. Union of India, 2011-9 SC 761. This case is very important in the context of black money, PMLA, and constitutional duties of the state. Ram Jethmalani v. Union of India 2011-9 SC 761. Background. A group led by senior advocate Sri Ram Jethmalani filed a petition before the Supreme Court seeking investigation and action against Indian citizens who had stashed black money abroad, especially in foreign tax havens like Liechtenstein. Disclosure of names of such individuals. Creation of a special investigation team, SIT. The petition alleged that the government had failed to take adequate steps to bring back black money from foreign bank accounts. Issues before the court. 1. Whether the Union government had fulfilled its constitutional duty to investigate the issue of black money held abroad. 2. Whether the government must disclose names of individuals who have foreign bank accounts. 3. Whether the Supreme Court should create a special investigation team, SIT, to monitor the investigation. Key findings of the Supreme Court. 1. Black money is a national problem. The court held that black money weakens the economy, promotes crime, corruption and money laundering, is linked to terrorism financing, violates Articles 14, 21 and 265, rule of law, fairness in taxation. The court emphasized that the government has a constitutional obligation to act decisively. 2. Duty of the state to investigate, Article 21. The state must conduct a vigorous and expeditious investigation into the issue of black money abroad. Delay or inaction violates citizens' right to fair and effective governance. 3. Creation of the Special Investigation Team, SIT. Most important holding. The court directed the government to form a Special Investigation Team, SIT, headed by Chairperson, Justice B.P. Jeevan Reddy, Reted. Vice Chairperson, Justice M.B. Shah, Reted. The SIT was empowered to monitor investigation of black money cases, direct various agencies like ED, CBI, FIU, CBDT, DRI, Submit periodic reports to the Supreme Court. 4. Disclosure of names. The government argued that names cannot be disclosed due to Double Taxation Avoidance Agreement (DTAA) confidentiality. The court held, all names of persons against whom prima facie evidence exists must be disclosed. Only names of people under mere suspicion need not be disclosed. Thus, full confidentiality was rejected. 5. Emphasis on sovereignty and rule of law. The court stated that India's sovereignty requires a strong stance on black money. Citizens must pay taxes and cannot hide wealth abroad. Failure to investigate encourages lawlessness. Significance of the case. 1. Landmark in anti-black money jurisprudence. The case accelerated the Indian government's efforts to trace unaccounted wealth abroad. 2. Foundation for stringent AML laws. The court's observations supported stronger enforcement under PMLA 2002, Black Money Act 2015, International Cooperation Treaties 3. CIT still active. The CIT remains the supervisory authority even today on black money matters. Important for exams. The case is highly important for PMLA, economic offences, black money laws, constitutional law, Article 21 duties of the state, good governance. If you want, here is a clear, concise, exam-oriented summary of the case Binod Kumar v. State of Jharkhand and Oz. 2011-11 S.C. C. 463. This case is important for criminal law, cheating, breach of trust, and quashing of fur under Section 482 CRPC. Binod Kumar v. State of Jharkhand 2011-11 S.C. C. 463. Background. The complainant alleged that the accused, including Binod Kumar, failed to supply goods after receiving payment advance. The complaint was filed under Sections 406, 420, and 120 BIPC, criminal breach of trust, cheating, conspiracy. According to the accused, the dispute was purely a civil contractual dispute, not a criminal offense. The accused approached the High Court for quashing under Section 482 CRPC, but the High Court refused. The matter reached the Supreme Court. Issues 1. Whether failure to perform a contract or return money amounts to cheating or criminal breach of trust. 2. Whether a purely civil dispute can be given a criminal color. 3. When can the complaint be quashed under Section 482 CRPC? Key findings of the Supreme Court. 1. Mere breach of contract is not cheating. To constitute cheating, Section 420 IPC, there must be dishonest intention at the time of entering into the contract. Merely failing to keep a promise or failing to return money does not automatically prove dishonest intention. The court held that it was only a commercial transaction gone wrong. 2. No criminal breach of trust, Section 406 IPC. For Section 406, two things are essential. 1. Entrustment of property. 2. Dishonest misappropriation. In this case, money was paid under a contract, not as entrustment. Therefore, Section 406 IPC does not apply. 3. Criminal prosecution cannot be used to settle civil disputes. The court strongly held that criminal law cannot be used as a tool for coercive recovery of money. If a dispute is purely civil, filing criminal case amounts to abuse of the process of law. 4. High Court should have quashed the proceedings. The Supreme Court held that the High Court erred in refusing to quash the complaint. The allegations in the did not disclose any criminal offense. Therefore, the court quashed the criminal proceedings under Section 482 CRPC. Important principles laid down. 1. Civil disputes should not be criminalized. 2. Dishonest intention must exist at the inception of the transaction for Section 420. 3. Entrustment is essential for Section 406. 4. Courts must prevent misuse of criminal law for settling scores or recovering money. 5. High courts must use Section 482 CRPC to prevent abuse of process. Significance of the case. This case is widely cited for distinguishing civil liability vs criminal offense. Scope of quashing of interpretation of Sections 406-420 IPC. preventing harassment through criminal complaints in business disputes. It is frequently used alongside State of Haryana v. Bajan Lal, G. Sagar Suri v. State of UP, Indian Oil Corp. v. NEPC India Limited. If you want, Here is a clear, structured, examinatory note on the case B. Ramraju v. Union of India, WP No. 10765, 2010, High Court of Andhra Pradesh, 2011-164 Comcast 149. This case is very important for understanding the constitutionality of PMLA 2002, especially Section 5, Provisional Attachment. B. Ramraju v. Union of India, WP number 10765 of 2010, High Court of Andhra Pradesh reported in 2011-164 Company Cases 149. Background of the case. The petitioner, B. Ramraju, challenged the constitutional validity of certain provisions of the Prevention of Money Laundering Act, 2002 PMLA. He argued that Section 5, Power of Provisional Attachment of Property, violated Article 14, Equality. Article 21, Right to Life and Personal Liberty. His argument was that attachment is allowed even before conviction, which is arbitrary and violates due process. Issues before the High Court 1. Whether Section 5 of PMLA, which allows provisional attachment of property before conviction, is unconstitutional. 2. Whether such attachment violates Articles 14 and 21. 3. Whether PMLA provides adequate safeguards to protect individuals from arbitrary action. Arguments of the petitioner. Section 5 permits attachment at the pre-investigation stage, which is excessive. There is no requirement of mens rea or direct involvement at the stage of attachment. Attachment impacts property rights and livelihood, violating Article 21. The procedure under PMLA is not fair, just, and reasonable. Arguments of the Union Government. PMLA is a special law enacted to curb a serious international problem. Attachment is temporary and subject to confirmation by an adjudicating authority, right pointing arrow, not arbitrary. Adequate procedural safeguards are provided. International obligations, FATF, require strong anti-laundering mechanisms. Key findings of the High Court. 1. Section 5 PMLA is constitutional. The court upheld the validity of the provision. Reason. Provisional attachment is not final confiscation. It is a preventive measure to stop the accused from disposing of property suspected to be proceeds of crime. It protects the larger public interest. 2. Sufficient safeguards exist. The court noted several safeguards. 1. Attachment is only provisional for 180 days. 2. It must be based on reason to believe, recorded in writing. 3. It must be confirmed by an independent adjudicating authority, Section 8. 4. The accused gets full right to be heard. 5. Final confiscation only after trial by special court. Thus, the provision is neither arbitrary nor excessive. 3. No violation of Article 14 or Article 21. The procedure under PMLA is fair, non-arbitrary, and reasonable. The law is based on intelligible differentia, distinct category of offenses involving proceeds of crime. The action is proportionate to the objective of preventing money laundering. Based on intelligible differentia, distinct category of offenses involving proceeds of crime. The action is proportionate to the objective of preventing money laundering. 4. PMLA is a preventive as well as penal statute. The court clarified, attachment is preventive, to preserve property. Prosecution for money laundering is penal, Section 3 and 4. Both aspects are valid. Importance, significance of the case 1. First major judgment upholding PMLA's validity. The case became a major precedent supporting the constitutional validity of Section 5, Provisional Attachment. Overall scheme of PMLA 2. Cited in later Supreme Court judgments, including the landmark case Vijay Madan Lal Chaudhary v. Union of India, 2022. 3. Strengthened the powers of ED. It confirmed that pre-conviction attachment is constitutional. 4. Helped India fulfill FATF obligations. The court acknowledged India's international commitments to combat money laundering. Exam-oriented short note answer. Section 5 of the PMLA was challenged as arbitrary and violative of Articles 14 and 21. The High Court held that provisional attachment is only a temporary, preventive measure and not final confiscation. Adequate safeguards like recording reasons, adjudication under Section 8, and judicial review exist. Therefore, Section 5 is constitutional. The writ petition was dismissed. If you want, I can also prepare Pushpin on-page summary Pushpin bullet point revision. Here is a clear, structured, exam-ready summary of the landmark judgment in Vijay Madan Lal Chaudhary and Oz v. Union of India, SLP, CRL. Number 4634 of 2014, decided on the 27th of July 2022 by a three-judge bench of the Supreme Court. This is the most important case on the Prevention of Money Laundering Act, PMLA, 2002. Vijay Madan Lal Chaudhary and Oz v. Union of India, SLP, CRL. Number 4634 of 2014, Judgment, 2022, also reported in 2022-10 SCC 235. Context. A batch of petitions challenged the constitutionality of several core provisions of the PMLA, including Section 3 Offence of Money Laundering, Section 5 Provisional Attachment, Section 17 and 18 Search and Seizure, Search of Persons, Section 19 Arrest, Section 24 Reverse Burden of Proof, Section 45 Twin Conditions for Bail, Section 50 Summons and Statements before non-police officers. Petitioners claimed these provisions violated Articles 14, 20, 21, 300 AETC. Issues before the court. 1. Whether the definition of money laundering, Section 3, is overbroad. 2. Whether pre-trial attachment is unconstitutional. 3. Whether ED has unchecked power to arrest, search, seize. 4. Whether statements under Section 50 violate Article 23. 5. Whether the twin conditions for bail under Section 45 are valid. 6. Whether PMLA violates constitutional protections of life, liberty, and property. Key findings, Supreme Court's landmark conclusions. 1. Definition of money laundering, Section 3, is valid. Section 3 covers any process connected with proceeds of crime. The phrase, and, read as, or, was upheld. Right pointing arrow thus, mere possession, concealment, or use of proceeds of crime amounts to money laundering. Mens rea is inherent in the words, knowingly, and attempt. Court's view, money laundering is a continuing offense so long as a person enjoys or uses the proceeds of crime. 2. Twin conditions for bail, Section 45, restored and upheld. The court upheld the validity of Section 45 after the 2018 amendment. To get bail in PMLA cases, the accused must satisfy 1. Court must be satisfied that the accused is not guilty. 2. Accused is not likely to commit an offense while on bail. These are stringent and constitutional due to the gravity of money laundering. 3. ED is not required to register INFOR. ECIR, Enforcement Case Information Report, is an internal document, not equivalent to INFOR. ED does not have to provide a copy of ECIR to the accused. A simple disclosure of reasons for arrest is enough. 4. Section 19 Arrest Powers, Constitutional. Director, Deputy Director must record reason to believe in writing. Judicial review is available. Arrest procedure is consistent with Article 21. 5. Search and seizure, Section 17 and 18, valid. No prior FOR required. Reason to believe, must be recorded and is subject to post facto checks. Sufficient safeguards exist. 6. Section 24 Reverse burden of proof is valid. The accused must explain the source of funds. This is justified because laundering is a special offense involving complex cross-border financial crimes. 7. Section 50 statements are not hit by Article 23. ED officials are not police officers. Statements recorded under Section 50 O are admissible, O can be used as evidence, O do not violate the right against self-incrimination. 8. Provisional attachment, Section 5, valid. Preventive measure to stop concealment or dissipation of proceeds of crime. Sufficient checks exist. Adjudication under Section 8. 9. PMLA is a special law with international obligations. Court stressed, India must comply with FATF standards. Money laundering threatens national security, economy, and sovereignty. Stringent law is necessary. Outcome: the Supreme Court upheld almost the entire PMLA framework, giving strong validation to the powers of the Enforcement Directorate. Only one part was read down. Retrospective application of the 2019 explanation to Section 3 right pointing arrow cannot be used to prosecute acts done before the amendment. Significance of the judgment 1. Biggest judicial endorsement of ED's powers. All major ED powers, arrest, search, seizure, attachment, were upheld. 2. Strengthened anti-money laundering regime. Courts now treat PMLA as a strict and special law. 3. Landmark for bail law. Twin conditions for bail revived right pointing arrow making bail very difficult. 4. Cited widely in later judgments. Especially in Gautam Navlakha cases, UAPA. P. Chidambaram bail case. Multiple High Court PMLA matters. Short 5-line exam answer. Vijay Madanlal Chaudhary v. Union of India, 2022, upheld the constitutional validity of all critical provisions of PMLA including Section 3, 5, 17, 18, 19, 24, 45 and 50. The court held money laundering to be a continuing offense and restored stringent bail conditions. ED's arrest, attachment, search, and non-disclosure of ECIR were upheld. Statements under Section 50 are not hit by Article 23. The judgment strongly reinforced India's anti-money laundering framework. If you want, I can also prepare Pushpina on-page revision sheet. Pushpina. Here is a clear, concise, exam-ready summary of the Supreme Court decision in Parvati Kolur and ANR v. State by Directorate of Enforcement, SLP, CRL. Number 4258 of 2021, an important judgment relating to PMLA, scheduled offences, and maintainability of prosecution. Parvati Kolur and ANR v. State by Directorate of Enforcement, SLP, CRL. Number 4258 of 2021 judgment, the 13th of January 2022, 3-judge bench, Justices A.M. Khanwilkar, Dinesh Maheshwari and C.T. Ravikumar. Context: the petitioners were prosecuted under PMLA 2002 based on allegations that they had received funds linked to a scheduled offense. However, the scheduled offense case ended in acquittal closure. They approached the Supreme Court arguing that when the scheduled offense fails, the proceeds of crime disappear. Therefore, the PMLA case cannot continue. Issues before the Supreme Court. 1. Whether a person can be prosecuted for money laundering, Section 3, when the scheduled offense has been quashed or resulted in acquittal. 2. Whether PMLA offense is independent of the predicate offense. 3. Whether proceeds of crime can exist without the scheduled offense being proved. Key findings. 1. If the scheduled offense case ends, PMLA case cannot survive. The Supreme Court held that money laundering cannot exist in a vacuum. It is entirely dependent on the existence of proceeds of crime generated from a scheduled offense. If the scheduled offense fails, right pointing arrow proceeds of crime vanish. Right pointing arrow Section 3 PMLA cannot be applied. This is consistent with earlier judgments in Aparna Shah v. State of Maharashtra, Directorate of Enforcement v. Gagandeep Singh, P. Chidambaram v. Directorate of Enforcement, Observations. 2. PMLA is not an independent offense when predicate offense collapses. The court clarified, PMLA offense is derivative. It arises only when a scheduled offense produces illicit money. If there is no unlawful gain, there can be no proceeds of crime. 3. Prosecution under PMLA is not permissible after acquittal, discharge. The Supreme Court held, when the trial court discharges the accused in the scheduled offense, or the complaint is quashed, or the accused is acquitted, right pointing arrow PMLA proceedings must automatically end. This flows from the definition of proceeds of crime under Section 2, 1U. 4. Consistent with Vijay Madanlal principles. Though decided before the 2022 Vijay Madanlal judgment, this case is consistent with the principle that Existence of proceeds of crime is foundational for the PMLA offense. The Supreme Court confirmed that if no money was generated from a crime, one cannot be charged with laundering it. Outcome of the case. The Supreme Court quashed the PMLA prosecution against Parvati Kolur. Held that no offense under Section 3 survives after discharge from the predicate offense. ED cannot run a case independently when the underlying offense no longer exists. Importance of the case 1. Foundational principle. PMLA depends on scheduled offense. This judgment is now frequently cited in bail and quashing matters under PMLA. 2. Relief to accused when scheduled offenses collapse. Accused can seek quashing of PMLA proceedings. After acquittal. After closure of predicate offense. After quashing of FIR 3. Reaffirmed ED's limits. The court held that ED cannot continue investigation when no scheduled offense survives. Short exam note, 5 to 6 lines. In Parvati Kolur v. State by Directorate of Enforcement, 2022, the Supreme Court held that prosecution for money laundering under Section 3 of the PMLA cannot continue once the scheduled offense is quashed, closed, or the accused is acquitted, discharged. Since the existence of proceeds of crime depends entirely on the commission of a scheduled offense, the PMLA case becomes infructuous. The court therefore quashed the PMLA proceedings. If you want, I can also prepare Pushpin a comparison with Vijay Madanlal Pushpin a table of cases where PMLA proceedings were quashed after acquittal. Pushpin a short on-page revision sheet. Just tell me. Here is a simple, easy to remember explanation of proceeds of crime under PMLA. Checkmark simplified meaning of proceeds of crime. Proceeds of crime means right finger any money or property that comes from a crime, and right finger that crime must be a scheduled offense under PMLA. Checkmark in very simple words. If someone earns money illegally from a crime, that illegal money equals proceeds of crime. Checkmark examples, very simple. 1. A person cheats someone and earns 10 lakh rupees, right pointing arrow 10 lakh rupees equals proceeds of crime. 2. A person sells wildlife illegally and gets 2 lakh rupees, right pointing arrow 2 lakh rupees equals proceeds of crime. 3. A public servant takes bribe, right pointing arrow the bribe money equals proceeds of crime. 4. A drug dealer earns money by selling drugs, right pointing arrow that income equals proceeds of crime. Checkmark important points, easy version. 1. Money must come from a scheduled offense. The list of offenses is given in PMLA Schedule 2. It includes checkmark cash, checkmark bank balance, checkmark land, checkmark property bought from illegal money, checkmark gold, vehicles, shares, etc. 3. If the main crime, scheduled offense, is not proved, then proceeds of crime do not exist. Star online definition for exams. Proceeds of crime means any property or money obtained directly or indirectly from a scheduled offense under PMLA. If you want, I can also give